Hello, everybody. Welcome to, I think now the fourth or fifth in Garden Court Housing Team's series of webinars. My name is Liz Davis. I'm one of the members of the housing team at Garden Court Chambers. And this seminar is on public law defences for Section 21 claims and claims for mandatory grounds for possession, principally rent arrears. It's highly topical, because although we haven't seen any possession claims since the end of March, as we all know, the moratorium on possession claims is due to end on the 23rd of August. After that date, then landlords will be able to issue possession claims in court, and of course existing possession orders, warrants for eviction and so forth will be able to be enforced. And there has been a wealth of evidence about the dire position that many, particularly private renters, are finding themselves in as a result of the economic consequences of coronavirus. A whole load of housing campaigns, including Shelter and Crisis, have voiced concern about what they call the tsunami of potential cases for possession because of rent arrears, not necessarily based on rent arrears as a ground for possession, but the landlord's motivation for seeking possession under Section 21 or whatever is because of rent arrears. There has been a lot of lobbying of the government, not just from the housing campaigns and the usual suspects, but also from the Local Government Association and from the House of Commons Select Committee on Housing, Communities and Local Government, where they are asking that the government bring forward its plans that it's already committed to from the Queen's speech in December to abolish Section 21, that they bring those plans forward so as to coincide with the end of the moratorium. And the House of Commons Select Committee and indeed many other campaigns are asking for more than that. They're asking for Ground 8 to be made discretionary, where arrears have accrued as a result of coronavirus, and for the reason for rent arrears, if they're due to coronavirus, to become a very significant factor when courts are considering discretionary grounds for possession. So far, the government's response has simply been that the reform of what they call the reform of Section 21, the abolition of Section 21, is a highly complex matter and therefore should not be rushed through. And so we do not expect to see any changes to the current law once the possession moratorium lifts on the 23rd of August. I do recommend to you proposals by Crisis that have now been taken up by a number of housing campaigns for what they call homelessness and the prevention of homelessness, where they have draft legislation that would require local authorities to continue emergency accommodation for a period of up to a year as lockdown starts to lift for all those people who are rough sleeping or at risk of sleeping rough. And they also, in their prevention of homelessness part, urge on the abolition of making Section 21 and Ground 8 discretionary. That's all on Crisis's website, and it's well worth looking at. But in the meantime, we have to assume that the law from the 23rd of August will be the same as it was when possession claims ceased on the 25th of March. And for that reason, we have this very timely seminar today to look at potential defences to mandatory grounds of possession. We have two excellent speakers, colleagues from Garden Court housing team. I'm going to introduce them both, do a bit of housekeeping and then hand over to them. Both are very familiar to our audience, I know. Tim Baldwin has a practice in housing, but also community care, court of protection, and broadly public law and human rights. He's got a number of reported cases. I asked him yesterday what his best case was in order to introduce him, and I agree with his choice. It's his very recent case of Akuru and the London Borough of Hackney, which was the second case to consider Practice Direction 51Z, the moratorium on possession claims, and held that that applied to appeals against possession orders, as well as the hearing of possession claims, and that's been a hugely important case that has stopped attempts to go round the moratorium. He's also a big campaigner around legal aid in general, civil legal aid in particular, and he's part of LAPG's advisory panel, and we've been very grateful to him in Garden Court for his work on amendments to the civil legal aid regulations. Sebastian Ilgetta has a practice in housing, homelessness and property, along with an international human rights element. He and I are working on a case that involves that. And when I asked him for his best case, he reminded me of the High Court case of Southwark and Ibeden, which is on his website profile. It was a High Court appeal against a possession order that had been made on the mandatory ground of subletting, and it's all about an intention to return and to continue to occupy. If you have a subletting case, that's very much the most important recent authority. Before joining us, he had a career working for Amnesty International as a researcher in Guatemala, Panama and Costa Rica, dealing with all sorts of human rights abuses, but most specifically for our purposes, including the human rights abuses of evictions of rural indigenous communities, and that informs his international human rights practice. A couple of things about housekeeping. What we've discovered with webinars, and we're delighted by this, is that of course we're able to host far more people than we have been able to host in our physical seminars held at Garden Court, where we can fit about 50 or at a pinch 60 people into our seminar room. We're joined today by over 200 people, which is fantastic. And some of you are people who regularly come to our physical seminars, welcome. And some of you are people who, for geographical reasons, have not particularly joined us in our physical seminars. And we hope that these webinars are really useful, and we will of course be considering continuing them when life returns to normal, because we have found this geographical audience and geographical extended audience, and that's absolutely great. I don't need to tell you to turn your mobiles onto silent, because all of you, except for the three of us, are on mute, and I'm really sorry, but you're going to stay that way. So if you have sounds of cats, washing machines, children, etc. in the background, that's fine. We can't hear them. For that reason, if any questions to the speakers, please put on the chat. I will be monitoring the chat, and at the end of the two talks, then I will select questions and I will ask those questions of the speakers. I will attribute them, but I'm afraid I won't go to you to ask the questions. And obviously, if you have questions after today, you're very welcome to contact myself, Seb or Tim at the usual email address, and we'll try our best to answer them. We're going to use slides. Don't worry about making massive numbers of notes. The slides will be sent to you automatically after today's webinar. And by joining today's webinar, you have all agreed to be recorded. But because you are on mute, the recording is of the speakers and not of yourselves. So we hope that is fine. And if you have any technical problems, our marketing department, Amy, who's with us today, has already put on the chat that please just put them on the chat and she'll do what she can to help. So that's my introduction, and without further ado, we start off with Tim Baldwin. Tim.
Thank you, Liz. I'm just setting up the slides. So you should be able to see the first slide in this presentation. What I'm going to talk about really is the context, the present context that we are in respect of, we might call the restoration of possession proceedings, and a little bit about how the stay operates and what it means. Then I'm going to talk a little bit about, particularly on section 21, and looking at defences and how one might craft a defence in the present circumstances. And then towards the end, I'm going to talk a little bit about the Trecarrell judgment, just to put it in the context of what we might have to expect in respect of possession proceedings. So the first thing I want to draw to people's attention is what the Practice Direction 51Z and the Coronavirus Act in respect of possession proceedings actually cover. So you can see that the Practice Direction stay, and it was intended to assess modifications to rules and practice directions that may be necessary during the coronavirus pandemic, and the need to ensure that the administration of justice, including enforcement of orders, is carried out so as not to endanger public health. So the key issue there was the protection of public health during the pandemic. And what the government has not actually acknowledged at the moment is that we are still presently within the pandemic. And as such, that they made to stay proceedings and to stay enforcement of any proceedings for possession. And it was limited to proceedings brought pursuant to under CPR 55 and all proceedings, all warrant and writ proceedings to enforce any order for possession. It didn't stop the service of notices, and it didn't stop the issue of claims, and it didn't stop applications for warrants. It was limited in that way, and it was enforced on the 27th of March, amended in April, and it was to cease having effect on the 25th of June. But then it was taken over by way of a regulation inserting a new rule into the civil procedure rule. So at present, it is a new rule, but it is time limited until the 23rd of August. So that is what we have. We have a stay in place, but we have a system whereby landlords can still issue notices and make claims for possession during the stay. So people have to be aware of that. Sorry, I'm having a little bit of technical problem getting the slide to move. There we go. So to flesh out what Liz said at the beginning, what is the government's present position on the stay? And the present position was answered in a written answer to an answer to a written question on the 1st of July. And it said, Lord Greenhalgh said that from the 24th of August, the courts will begin to process possession cases again. He said this is an important step towards enabling lockdown and will protect landlords' important right to regain their property. So the focus of the government seems to be the right to recover property for landlords. It then goes on to say that work is underway to create some sort of system so that just decisions for vulnerable tenants is being arranged with the advice sector and judges. It does indicate that there may be new rules, but there's not going to be any legislation. And you can see that Parliament is effectively on holiday from July until September. The notices that are presently provided for under the statute, that is any notice issued from the 26th of March until the 30th of September, and I've given you the reference to the schedule there, purports to amend Forms 3 and Form 6A to extend the notice period for 3 months. This also applies to introductory tenancies and also notices to quit. So what there is there's an extended period before which a landlord can recover possession. But naturally, if a landlord issued one of these new notices on or around the end of March, the 3-month period has ended. So there may be a large number of claims issued. We don't know. As Liz indicated, considering the potential impact, what mitigation was proposed? Well, the Housing and Communities and Local Government Committee did publish a report recommending that once the courts reopen, they be given a discretion to dismiss Section 8 notices for rent arrears and Section 21 notices until the 31st of December. However, this isn't being adopted by the government, and we're in a position of having to rely on the present law as we understand it to be, possibly the introduction of some new rules in respect of court proceedings. We don't know if those are going to manifest themselves. And in reality, the skill and judgment of those representing tenants, and also the approach of judges. So looking at Section 21, for example, the most recent publication in Inside Housing suggests that almost 250,000 renters risk eviction when the ban lifts, and that's from Shelter. And we're well aware that Section 21 proceedings operate via essentially two different routes. Either the accelerated procedure, whereby even if there are rent arrears, the landlord forgoes those rent arrears and goes for effectively a paper application. It is possible to defend those proceedings, but most of those types of proceedings that I've seen myself involve actually applying to set aside. So it's always the case that I've experienced that very rarely does a tenant get to the situation where they can put in an effective defence that turns those proceedings into a oral hearing, but rather that you are looking at the case when the possession order has been made, and then you consider making an application to set aside that order, which is provided for within the procedure. I would say that sort of advisors should start looking at trying to encourage people to approach them to actually put in a pleaded defence to the accelerated procedure, because if that creates at least an arguable case, then the judge will remit it to an oral hearing. It's often very difficult, in my experience, to get a really good result from set-asides. You can, but you really have to get a lot of instructions and a lot of information from the client to do that. The alternative traditional route is if there's nothing to stop a landlord, whether they be a public sector landlord or a private sector landlord relying on Section 21, to issue an actual traditional claim for possession under the non-accelerated procedure, so that arrears can be claimed as a money judgment. The question here is always, in any type of Section 21 proceedings, can you use, say, a counterclaim for disrepair at all if it is not actually linked to the cause of action? Because primarily Section 21 is a pure claim for possession, and the money judgment, for example, rent arrears, is one which is almost like an ancillary order. It's not the cause of action. It's bringing two separate claims together. So can you think about bringing a counterclaim? That is trying to actually to sort of link it to some form of defence. For example, in either case, if a reason for either a public, for example, a public landlord, an RSL, was bringing a possession claim on the basis of Section 21, if part of their reasoning for bringing that claim was rent arrears, and you had a disrepair claim, is it arguable to then bring a counterclaim for disrepair because it's linked to the actual reasoning for the decision? So that somehow you have to try and, in any counterclaim, disrepair or damages, try and actually link it either to the reason for bringing the claim or somehow craft it into a defence. And you have to also look always at the lifetime of Section 21 notices. The present legislation, as I understand it, provide that once a notice is issued, you have 6 months thereafter to bring the claim for possession. That might be something that is missed during this stay, because there will be notices that are issued before the stay, notices during the stay, and old notices. So really look at whether the notice can be invalidated in any way, shape or form, because that is the key to defending the claim under Section 21. So for private landlords, you're dealing primarily with procedural defences. And if you remember the case of MacDonald and MacDonald in respect of whether Article 8 can apply against a private landlord, the Supreme Court essentially held that the legislation under Section 21, the Housing Act 1988 and 89.1 provided the right balance for Article 8. But you have to now query the impact of local lockdowns on whether that would actually still apply. For example, if one goes back to the rationale behind the stay, it was to protect public health. One of the elements in having a legitimate aim to breach an Article 8 right is to protect public health, and then a proportionality assessment. The question being, for example, could the fact that you had a local lockdown in the absence of a stay mean that the court itself, as a public body, would have to look at whether the fact that there's a local lockdown, could that be a relevant matter to shift an Article 8 balance, which was something that was not considered by the Supreme Court in MacDonald and MacDonald. I just put that out there for people to think about, because it's something that arguably the stay is a human rights protection, and how do we deal with that with local lockdowns? For example, if there was no stay in Leicester, how would the courts react in eviction proceedings? If you have a claim in Clerkenwell and Shoreditch and you have a lockdown in Southwark, Clerkenwell and Shoreditch is not in Southwark, but it has cases coming in from Southwark. How is it going to address that versus cases, say, from Hackney, which might not have a lockdown? It is something to think about. And also, will there be a pre-action protocol for private landlords, or a rule change that addresses some of these issues? With RSLs, housing associations still use starter tenancies, for example, so they have ASTs. So again, you are straying now, although the procedure itself is compliance with procedure itself is a necessary requirement to recover possession under Section 21. RSLs are arguably acting as public bodies. So you have to look at things like their policies, the existing pre-action protocol, part 3, and whether they're complying with that, and their review process, especially with starter tenancies, and the possibility of the engagement, the availability of public law and Article 8 defences when you have an RSL as a landlord. So what I've called newest procedural defences. What I've given you there is the link to the present Form 6A, the present required notice that has to be served by anyone relying on a Section 21 claim during the pandemic, during the stay. One of the interesting features is, although there is a supposed amendment to the form, there's no amendment to section 21(4)(d). So where a notice has validity from 6 months from the date of service, save now it's 3 months rather than the 2 because of the period of the tenancy. Normally it would be after you serve it, you have another 4 months from the expiry. But this means that what you have is a reduction in 3 months from the end of the notice expiry date. So for example, traditionally sort of a landlord would have 2 months. They have to then issue their claim after that 2 months and before the expiry of the 6 months from the date on which they serve it. So they have a 4-month gap. Now they have a 3-month gap. So you should be aware that some landlords or some landlord advisors may not be fully aware of that issue. So they could have served a notice at the beginning of the stay, thinking they can then issue a claim after the expiry of that notice, but get this period during which they can issue the claim wrong. And you can see that there's a slight variation in respect of a valid notice under section 21(4)(a). So that is expressly stated on the notice, but it may be something that landlords get wrong. And you should be astute to that. Take a close look at the notice what this notice provides for. Here is a rather controversial aspect of a procedural defence, and this is something that Giles Peaker has pointed out in the Nearly Legal website, and it is the wording of paragraph 12(2) of the schedule. And it says the schedule to assured tenancies and agricultural occupancies forms England regulation 2015 is to be read in relations to notices given under sections 21(1) or 4 of the Housing Act 1988 during the relevant period, as if in form X6A notice seeking possession of a property let under an assured tenancy, and then it goes into the other elements. So he said the Act says that the previous 2 months form is to be read as if it said 3 months. And it's also similar wording in Form 3 for Section 8 claims. And he's posited that there's some uncertainty as to whether this is actually an amendment of the form or how it is to be read. And it is said on the form, it is said by reference to be by amendment under section 81 and schedule 29 in the introductory text on the form. But it's not something that's actually said within the Act. It's not said in the schedule that it's actually an amendment in the manner in which you have seen it expressed within statutory instruments that have done these form amendments in the past. So he's questioning effectively whether the use of the words be read as is actually an amendment, and therefore whether the actual statutory form is a valid form for the purposes of giving notice. My own personal view is that you can try it, but it'd be a very bold judge to say, in interpreting these words, to say that this could not be construed as an amendment. No one's actually formally put any form of challenge or anything forward to say this, but it's a proposition. It's a proposition. And I just anticipate there'll be days when some people so desperately will rely on this and say, it's not a valid form, it's not been validly made, and you cannot rely on it. Then the next day, when someone issues a claim prior to the 3-month period, say, well, they haven't issued a claim in accordance with the form. But it's something to think about. It's something to think about, and it's something that's come up. Is the form a lawful form? But let's put that to one side and just remind ourselves of what you have to have in terms of procedural defences. And the key thing is the validity of the notice and the validity of the procedure that's adopted. So you always have to consider, in addition to dates, service, and so on, what all these elements of the Deregulation Act, deposit protection, licensing requirements, fees, proper authorization, and there's a useful timetable that is set out in the link in the shelter site. What I'm going to touch on very briefly is the Trecarrell case, and this all deals with the issue of the service of gas certificates prior to use of a Section 21 notice, and the issue about whether a valid notice, a valid gas certificate has to be given to a tenant prior to their occupation of an assured short-hold tenancy. And I've outlined the various regulations there, but in essence, this was a landlord's appeal related to the construction of Regulation 2.2 of the assured short-hold notices and prescribed requirements regulations in the context of the gas safety regulations. So I'm going to skip as to how the dispute arose. You can read that in your own time. So what did the Court of Appeal decide? And it was a 2-to-1 split. And I say that the judgment is unclear. I'm using that in a charitable way. It's unclear. And this is the Court of Appeal's reasoning by a majority. This is Lord Justice Patton and Lady Justice King. It is set out there and you can read it at your leisure. But they accepted that the policy reasons for there being a service of a gas safety certificate prior to a tenant entering into the tenancy had merit, it had a value. And the parliamentary discussions that occurred in the Lords, although not definitive, seemed to go in that direction. So the original, the outcome is, well, Regulation 2 meant that a tenant must be provided with a valid gas safety certificate, but under 36(6), but it's not time limited. So there must be one provided, but it doesn't have to be provided before the tenant goes into occupation. It can be provided prior to the service of the Section 21 notice. But there are peculiarities, and there's still a factual dispute in respect of whether an actual notice was served. But if one looks at the details of the judgment, there's a tortured way in which the regulations are interpreted, and it is contrary to the plain wording of the regulations. And that is what Lord Justice Moyland picked up in his dissenting judgment. And what I would say is that this is not the end of the matter, because even where we are on this case, there seems to be no actual direct discussion or direction as to whether what would constitute a valid gas safety certificate. How old is it? How old is it before you provide it? Is it 2 years old? Does it have to comply with any time limit? And basically Lord Justice Patten said no, but there has to be one provided. And what I would commend to you is there's a really excellent analysis in a video by Richard Cherry, who was the Tenant Council, and also if you read Giles Peaker's blog, I understand may have been the instructing solicitor for the landlord. I may be wrong. I know that Anthony Gold were for the landlord, but he expresses clear doubts as to how this judgment was arrived at. It's clear that there are a lot of things that really have to be looked at, but at least the take-home message is there has to be some form of gas safety certificate served on the tenant prior to the landlord issuing a Section 21 notice, and that has to be a valid one, whatever that means. So I'm going to stop now and hand over to Seb.
Thank you very much. That was great. Just to remind people that the slides will be sent out, and as Tim said, over to Seb.
Thanks. Have you stopped sharing, Tim, your screen? Okay. I think it's that one. Share. Is Liz? Is that the right one?
Sorry, yes.
Yeah, it is. Thanks, Liz. Thanks. Sorry about that. We just had problems prior to starting sorting out which screens would be shared. Right. I'm going to talk about defences to mandatory grounds, and those include procedure, counterclaims, discrimination, and public law and Article 8. It's a lot of material. And the idea behind this part of the seminar was to think about the most common scenario that many of you will be facing when defending possession cases once the courts resume full business. By now it's a trite point that we're all expecting a deluge of cases. So what we're trying to focus on in this part of the seminar is really the nuts and bolts of how defences to mandatory grounds work and what kind of things to look out for. It's a relatively brief overview, and some parts are quite basic because it's an immensely large area of law and procedure. Each individual topic could easily be a seminar in of itself. So to start off with, yep, got that working. The first thing I would look at when before going on to consider, I suppose, the more interesting equitable and public law defences is the humble procedural defence. I'm not going to repeat all that Tim said about procedural defences, but I just want to touch quickly on some things that are particular to assured and secured tenancies, and focusing more on assured than secured tenancies, because obviously we are expecting more ground 8 claims than we will be ground 84A in the 85 Act. So as Tim's mentioned, the notice seeking possession must be in either the prescribed form or in a form substantially to the same effect. But note the relatively recent case of Pease and Carter. I've set up the link and the citation there. It was handed down on the 17th of February this year, so just before lockdown. I can't imagine it's received a lot of treatment or attention in the county courts. The key fact of Pease and Carter is that the notice seeking possession in that case got the date wrong, but in a very obvious way. It was served on the 7th of November 2018 and should have stated that the proceedings wouldn't be commenced before the 26th of November 2018, but instead it stated 26th of November 2017. Now, the covering letter that accompanied the notice did state the correct date, and the context is correspondence all happening in 2018. Now, of course, a notice can't be dispensed with when relying on a mandatory ground, but the judge at first instance did allow an amendment. That was appealed to circuit judge. We found that while it was clearly an error and would be understood as such by the recipient, and I'll return to that because that's a very important point, the reasonable recipient test the circuit judge found did not apply to Section 8 because the requirements of Section 8 were very straightforward and the consequences of defect not very significant, because what he was getting at was that a landlord can simply serve a new notice and then start proceedings again. The Court of Appeal disagreed. The key point is that the court held that Section 8 notices were subject to the reasonable recipient test, and it took that concept or idea from the 9 investments I've set out in the slide. By the way, I should say they're all hyperlinked, so if you click on that, it will take you to Westlaw. I'm not really sure how many of you have access to Westlaw, so it's a bit of a gamble, but I'm hoping many of you will. And I've set out the quote there. I mean, in a nutshell, the reasonable recipient test is an objective test, and it's looking at how the notice would have been understood, and also looking at the context. So at first blush, one might think that Pease and Carter is a weakening of the protection afforded to tenants, and arguably it is, but it's also really important not to overstate the damage done for tenant defences. The Court of Appeal made it crystal clear that they found for the landlords in that case because the error didn't really alter the basic point of the statutory framework, which was to give the tenants 2 weeks' notice. Now, I've set out the key paragraphs per Arnold in Pease, per Lord Arnold in Pease and Carter. Now, in a nutshell, he's making the point that by asking the question, if the defective notice failed to give the tenants 2 weeks' notice, or failed really to give them what he refers to as that 2 week warning, that period of time which they can try and sort things out. So my reading of Pease and Carter and my suggestion would be to consider the precise type of error contained in the notice. So where you have an error which leads to a misunderstanding of the notice period, in other words, that the recipient had not understood the correct period that he or she had to try and fend off the claim, then that fails the reasonable recipient test. And I emphasize here, I don't mean, and I don't think the Court of Appeal means factually how much time they had. So if they did in fact get more than the notice period that was required. Now, of course, the notice period has changed. It's 3 months. It's not about how much factually they got, but how much time they understood they had. And that's really the key point. As long as they understood they had the correct time, then it should pass the reasonable recipient test. And if they didn't, then it doesn't. The most practical example I can think of is where there's an error as to perhaps the day or month more than to the year. Although arguably, if the error is in relation to a future year, then I would certainly run the argument that it fails the reasonable recipient test. What I mean by that is, for example, if you receive a notice to the effect of possession must be given up by the 9th of July 2020, and all the correspondence, it takes place in 2020. But there's an error in the notice, and it says, instead of saying 9th of July 2020, it says 9th of July 2019. Then that's clearly an error because 9th of July 2019 has already passed. But if there's an error as to the year going forward, 9th of July 2021, then it's quite reasonable to say, well, the recipient thought they had a year to sort things out. So that's why I say it focuses on the understanding of the recipient. Right. Now, Tim has already talked about some of the potential complications, or put it a different way, the opportunities for getting things wrong because of the operation of the new Coronavirus Act and Schedule 29. And Tim mentioned that it's really important to be astute to those kinds of issues. And what I find is that quite a lot of the time, there is nearly always, there's quite often a conflation between the date of posting versus the date of service. It's very common for those two dates to be conflated. That is to say, an assertion to the effect of because something was posted on a certain date, that means it was served on that date. and the introduction of Schedule 29 and Regulation 6 of Coronavirus Act 2020, changing the notice periods from 2 weeks to 3 months, adds a whole field of potential for confusion. So I would look up, always start by checking those kind of things. In relation to that, you can rely on CPR 626 about the right framework for notice periods of serving documents other than the claim form. I have been in situations where the landlord has argued that CPR 626 doesn't really cover the service of notices. And I mention it because I've come across it, but I don't really think there's much in that. I think the service of documents framework provided by the CPR is the most appropriate thing to follow when talking about the service of documents. I mean, saying it aloud is kind of the argument in and of itself. Finally, just in terms of procedure, the Court of Appeal on Tuesday handed down a case called Jarvis and Evans. Obviously, they knew about the seminar and wanted to make sure all the points were clear and everything. It's a discrete point. It applies only to Wales, and the court held that because of the operation of the Housing Wales Act 2014, which requires landlords to be licensed, only a licensed landlord can serve a Section 8 notice. The argument had been that a notice seeking possession, unlike a notice to quit, doesn't actually terminate the tenancy. That comes later when a judge decides that the tenancy is terminated. But the Court of Appeal didn't agree and said that, in a nutshell, to serve the notice, there had to be a licensed landlord. So if you're practicing in Wales, that's an important point to look out for. In relation to counterclaims, and I just want to briefly add on to what Tim said in relation to Section 21 counterclaims. With respect to a Section 21 counterclaim, there are two things that the landlord will be pressing when they're faced with the prospect of a tenant who brings a counterclaim. First of all, like Tim said, the landlord will say that there's no need to try the issues together. They want to sever the issues because the landlord just normally wants possession as quickly as possible. And if there's nothing to pick at in terms of the notice or something about the procedure of the claim, then that is an argument to be contended with, because it won't really have effect on possession if the counterclaim is successful. But if there's anything that can be challenged about the notice or the claim, even though disrepair, for example, is completely factually different, then in addition to what Tim said, I would suggest also that you can rely on the court's case management powers in respect of saving time and expense of trying the two things together. For example, it's likely that it will be the same person giving evidence, both in respect of any challenges to the factual aspects of procedure. In other words, the notice wasn't served on this date, like the landlord says, it was served on this, it wasn't served at all, it was served on this later date. It would be the same person giving that type of evidence as the person giving evidence about disrepair. So you can make an argument that the two things should be tried together. If you do bring a counterclaim, it's more likely than not that the landlord will try to recover the rent owed by way of defending that counterclaim. And it's a very tactical and fact-specific question. If the amount owed in rent arrears is more than the value of the counterclaim, then of course it might not be worth it. And finally, just on that point, there is the question around funding. If the disrepair is bad enough, then there's always the serious risk to harm point, which is available in paragraph 35 of Schedule 1 to LASPO. And for some of you, it will be possible to conduct a case partially publicly funded and partially funded on a CFA. But the point to all of this is not to negate the fact that a counterclaim, say for disrepair, provides a defence to a Section 21. It doesn't. But that's only half the perspective of a landlord, in my view. Landlords often settle cases, and if they're faced with the prospect of a counterclaim for disrepair that has merit and substance, which will be tried, then it opens up a whole field of possibilities in terms of settling the case, even if you can't keep your clients in possession, it still leads to the potential of your client being in a better position should they have to surrender possession eventually. In respect of counterclaims to Section 8 claims, of course, that's fundamentally different. It does act as a defence. It is, in effect, an equitable set-off. So funding should be much less of a problem, although, of course, I don't put it past the LAA to complicate matters. So just a couple of quick things to note. Unless the facts are such that recovery beyond a period of less than 6 years isn't an issue, for example, if the tenancy is just a couple of years old, then it's always really good to rely on Section 36 of the Limitation Act. Because a counterclaim is in effect an equitable set-off, the limitations imposed by the Limitations Act of 6 years recovery don't apply. So even minor disrepair, something that could be 3 or 5% of the rental amount, can add up to a very large amount if it's over 8 to 10 years or something like that. So always consider that. In respect to when to file a counterclaim, of course, as Tim mentioned also, in an ideal world, we'd file fully pleaded defences and counterclaims before the first hearing, and hopefully you'll try to do as much of that as you can. But if you do find yourself with a direction to file a defence in 2 to 3 weeks, and then you get instructions to the effect that give a counterclaim some substance, you don't have to have raised the issue of the counterclaim at the hearing or have a specific direction to that effect. Because of the operation of CPR 20.4, you can just file it along with the defence. So you don't have to have raised it at all at the hearing or have a specific direction to that effect. Just go ahead and file it if you get instructions to that effect. Okay, so that was briefly in relation to counterclaims. I'm going to move on to talk about the pre-action protocol. The part that applies, of course, to mandatory grounds is part 3 of the protocol. It sets out in a nutshell what the landlord should do, which is write to the tenant, consider the answer and give reasons for proceeding. The problem, I think, with the part 3 of the protocol is that there's no real clear sanctions of what happens if that part isn't complied with. Unlike part 2, which relates to discretionary grounds, it's very clear what should happen, and that's the taking into account of that when the judge is considering reasonableness. So what can you do? Part 3, lack of compliance. It can be pleaded as a public law point. Housing associations are subject to public law defences. I've set out the relevant cases there, again with their links. And some of my colleagues disagree with me, but I actually think that the county court is a better place to run these kind of public law points, because you can argue about the facts and you can hone down on what the aims of the housing association are, and all those kinds of matters. And in fact, sometimes I've had cases where a public law point becomes clear through the evidence of a housing officer or similar. And you can argue about the facts, of course. But the points you can take, these are just suggestions, but if a review doesn't happen at all, then you're really looking at procedural impropriety. But if it's done, but done badly, then I would suggest something along the lines of rationality. I think it's very, very fact specific, but those are just some of the ideas that you can think about. One of the most common areas for raising public law points is in relation to the policies that housing associations and local authorities have, not just arrears collection, but also very often their vulnerable tenants policies, disabled tenants, and other similar policies. And the kinds of questions to ask or the issues to look at are whether there has been any formal compliance. In other words, if the landlord contends itself that it has complied with those policies, and then to look in more detail of how they assert they have complied with those policies and whether it would have made a difference. And there's normally, because there are different actors and sometimes even different offices within housing associations and local authorities, it's quite often that the policies haven't been complied with to the fullest. Now, something else that's often used in public law is Section 11 of the Children Act. I did put the right year. In my notes, I put the wrong year. Section 11 of the Children Act 2004. I'll first look at the main requirement of Section 11. If you look at Section 11(2)(a), the main obligation it imposes is to have regard to the safeguard to promote the welfare of children. It can be a difficult issue to run, because per Section 11(1), it applies to local authorities, and so it makes, it's something that is used and can be used in a very straightforward manner in respect to local authorities, but because of that, it can be difficult to apply to housing associations. However, just going back to 11(2)(b), it does leave open the possibility of using in housing association cases, because there is a provision there that any service provided by another person pursuant to arrangements made by the person or body in discharge of their functions are provided having regard to that need. So there is an argument that depending on the degree of involvement of the local authority with any housing association, tenancy, or in another capacity, it opens up the possibility of being able to either join the local authority or being able to explore that issue as to what degree of involvement the local authority had in either authorising possession proceedings, or were they consulted, or things like that. I set these things out to perhaps set out the ideas, but it's something that will be very fact specific. For example, somebody in temporary accommodation in which there's a private landlord, often the local authority retains a degree of involvement, and often it's the private landlord bringing possession proceedings with the either explicit or tacit approval of the local authority. So in those kind of cases, if you get instructions with sufficient time and you write to the LA and try and explore these issues, there is scope for using Section 11 in relation to non-local authority tenants. If you do manage to use Section 11, then just changing the slide. Sorry, just one moment, just adjusting my slides. If you can run a Section 11 defence, then the substantive points I would suggest are set out in two cases, ZH and Zumbas. ZH first, the point I've set out in the slide is in respect to the hierarchy of consideration that must be given to the child's best interest. It's not something that trumps all other considerations, but if I were to summarize that quotation in a couple of words, it would be that it has to rank highly. It has to be a very serious and significant consideration, but it's not a trump card for absolutely everything. The second case at Zumbas sets out the more practical steps as to what a Section 11, what consideration of the child's best interest looks like. Lord Hodge refers to proportionality assessment, making the best interest a primary consideration, but not the only one. I'm not going to go through all of it, but I've set out the points, the steps in this slide, and it finishes in the next one. And I'd also note that there is a relatively recent case of Hertfordshire County Council and Davies, which, although in that particular case the Section 11 defence failed, the court did reaffirm that Section 11 defence in principle does operate to defend against possession, even in the absence of a private law right of the tenant to stay there. Okay, so those are some comments in relation to public law. The next thing I'm going to talk about is the Equality Act. This is a massive area of law, and I want to start talking about what I'm not going to talk about. There are various different forms of discrimination, And I'm going to try and focus on the most common defence, kind of defence that arises, which is disability discrimination. But just to mention very briefly the others, there's direct discrimination, which is exactly that. We are evicting you because of X protected characteristic. Indirect discrimination, an application of a policy which disproportionately impacts people who possess X protected characteristic. Reasonable adjustments does occur more. It is also quite prevalent in the field of housing law. And in effect, it's a landlord failing to make some kind of adjustment because of somebody's disability. And of course, there is the public sector equality duty. Now, because of time constraints, I'm only really going to talk about disability discrimination, but I would note that in particular, the reason I'm not talking about public sector equality duties, because my colleagues Shushin Liu, Ed Fitzpatrick and Nick Bano gave a seminar entirely on the issue of PSED a couple of weeks ago, and I am a few weeks ago, I think it was in May, and I'm told that the slides are available. So if you're really interested in PSED, do let us know and we can get the slides to you. But purely in terms of the disability discrimination, the key section, of course, is section 15. And it's a really good to return to this section again and again if you are pursuing an Equality Act defence. It's good to think of it in three parts. So there are two limbs to section 15.1. It's A and B. That's the way to think about it, in my view, would be 1A, causation, and 1B, proportionality. And then there's the issue about knowledge, which is in section 15.2. So a person, A, discriminates against a disabled person, B, if A treats B unfavourably because of something arising in consequence of B's disability, and the proportionality limb, A can't show that the treatment is proportionate means of achieving a legitimate aim. And then you have the knowledge point that the discriminator has to know about the disability in subsection 2. The other important sections, there are two others I'm going to draw your attention to. Section 35 is about management of the premises. I've got a bit of a philosophical view about this section, partly because my roommate's an employment law barrister, in addition to being a housing law barrister, and we often discuss these points. In my view, section 35 is about the context where discrimination can happen. So it's about, as it says, a person who manages premises must not discriminate. But it doesn't actually take you anywhere in terms of being specific as to what kind of discrimination you are alleging happened, or if you happen to be defending against it. What kind of discrimination is actually happening. It can still be indirect disability discrimination, direct discrimination, etc. So I would never not plead the substantive discrimination which my client alleges occurred. In this example that I'm using of disability discrimination, I would never not plead section 15. It doesn't hurt to add on section 35. I mean, it's on point. It's about the housing context. But I'd be wary of relying solely on section 35. To my reading, it's about the context. So you would always, my suggestion would be to focus on section 15 and to go back to section 15 to see how your case is shaping up. Now, the other important section is 136, and it, in a nutshell, it reverses the burden of proof, but I'll come back to why that's important as we go on. So in general, to just give you a very brief outline of what an Equality Act 2010 defence looks like, the first question you need to ask is your client disabled? It has a very specific definition. It's not only does he or she have a physical and mental impairment, but what the effect of that physical and mental impairment is on normal day-to-day activities. Then you look at the question of knowledge. Did the landlord know? Now, they don't need to know the particular diagnosis. They don't even need to accept that the tenant is disabled as a matter of law. But they do need to know about the facts of the disability. And I'll come back to that point in a minute, the issue of timing. it's also important to remember that in terms of timing, it's an ongoing duty not to discriminate. So if you're in a position that it's unarguable that the landlord knew nothing of the disability, and that only upon serving the defence for the very first time, it is that the landlord knows about the disability, that's not the end of the matter. Possession is determined on the day of the final hearing, and the judge has a decision to make on that day as to whether or not a breach of the Equality Act has occurred. And whereas previously the landlord may not have known of the disability, at that point on the final day, the landlord does know about the disability. And is still proposing, by continuing to seek an eviction, is still proposing to treat unfavourably your client. So it's not the end of the matter if it's unarguable that the landlord knew nothing about the disability. You can still run an Equality Act defence. Is seeking possession unfavourable treatment? Yes, that's set out crystal clear in Astor Communities and Ackerman Livingston, one of course the most famous leading cases on the issue, paragraph 16. So once you've considered those things, you then, as I say, it's always good to go back to section 15 and think about it in terms of that structure, the two limbs of 15.1 and 15.2 knowledge. You go back to 15.1, and I'm sorry I've made a typo there, it should say 15.1a in the slide, to think about causation. And this is a very important thing. Disability does not have to be the sole cause of the unfavourable treatment. It has to have a significant influence on the unfavourable treatment, or a cause which is not the main or sole cause, but is nonetheless an effective cause of the unfavourable treatment. And very importantly, motivation is irrelevant. You'll likely find arguments to the effect of the landlord not being motivated by the disability. Doesn't matter, that's at this stage, that's irrelevant. So as long as there's some significant influence or a cause in some way, then there is a defence there. And sorry, that was the case of Hall and Chief Constable of West Yorkshire, and that was affirmed in NASA and NHS England, which sets out even more precisely the steps that you have to think about when considering causation. I've set them out there. Again, motives are irrelevant. And it set out some useful guidance about the chain of causation. So, of course, the more links in terms of the chain of causation as a disability, the harder it's going to be to prove, but not necessarily impossible or even difficult. So it's only after going through all of that knowledge, causation, what that means in terms of the role that disability has in your causation, it's only then that you get to the proportionality question. And the type of evidence and the arguments fundamentally change from the perspective of the landlord. The arguments will have been assertions to the effect of your client's not disabled, or they didn't know his disability and that's not why they started the proceedings. They go from that to, in the proportionality question, this is all we did to help your client manage his or her disability. We've done everything we can. We can't do anything else but to obtain possession and to evict your client. So what do these arguments actually look like in practice? I mean, it's easy to initially agree with the first step and the second step, that the objective is sufficiently important to justify the limiting of a fundamental right and that the measure is rationally connected. So you can think of those in terms of obtaining possession is the securing the arrears is the legitimate objective, and that's rationally connected to evicting your client. In practice, I found that although that might have been initially the objective, it's very common that by the time you get to the final hearing, that there's some kind of payment proposal in place. Your client by then will have had weeks, if not months, and there's some kind of proposal to pay things off. And what does that, if there is, some kind of payment plan, what does that say about the rational connection between securing arrears and the eviction of the tenant? Because on the contrary, if there is a plan in place to pay back, to pay the arrears, then actually evicting the tenant is a guarantee that those arrears will never be recovered. So if you're defending on the basis of an Equality Act defence, it's important to take the task, the landlords, in terms of them defining what these objectives are, and often that will come out during the evidence. It's during the evidence that you'll get to the bottom of the reasoning of the housing officers or other witnesses on behalf of the landlord as to what they really want to achieve. In the third step, where the Supreme Court has said that the issue to consider is the means chosen are no more than is necessary, what you're really going to argue about is what the alternatives to possession are. For example, actually supporting the tenant to manage his or her disability so that he or she can pay the rent. And it's only after going through all of those points that you get to, I suppose, what is the pure proportionality question, which is step 4, which is that, you know, the balancing, the proportionality in its purest sense of whether evicting a client is balanced by the landlord's desire to recover arrears. So it's quite a long process, but those are the things that I would suggest you need to be considering. And don't forget Section 119 of the Equality Act. It allows you to bring a counterclaim for breaches of the Equality Act, and that can be pleaded in a very straightforward manner. I've heard some voices relating to Central London County Court, where a very famous housing law judge has made comments about how to plead an Equality Act counterclaim, but I think the Section 119 is very clear. It's the breaches of the Equality Act which are the basis of a counterclaim. So if you've set out how the Equality Act has been breached in your defence, then the counterclaim can be very, very short. Now, I just want to say something very quickly about avoiding summary possession. This again goes back to the idea that come the end of August or beginning of September, many of you will be faced with Ground 8 claims and will be resisting submissions to the effect of we want summary possession. In Ackerman Livingston, Lady Hale says summary possession, well, the Supreme Court says summary possession is not suitable for disposing of these issues. She sets out conditions where summary possession can be granted. So it's not saying that summary possession can never be granted. It's simply saying it's not suitable. It can be granted if there's just, you know, no prospect of your client being defined or being found to be rather disabled, and no possibility of making those connections. But it's not really suitable because it's about the types of evidence. At the first hearing, you won't know whether the landlord accepts, well, you probably won't know whether the landlord accepts that your client's disabled, and you won't have any evidence about the extent of that disability, the extent of knowledge. You won't have evidence about the causation, and all of those kind of issues are simply not suitable for determining in a 10-minute hearing. So that's why it's not suitable. But I would suggest that if you're turning up to the first hearing, you have those paragraphs in relation to summary possession handy, whereas if you have a future hearing, or when you take your instructions, you're thinking about that structure of 15.1 A and B and 15.2, the knowledge point. And finally, just to round off, I can see that I'm on about 35 minutes. Finally, I just wanted to echo a point that Tim made, which is in relation to MacDonald and the human rights point. The reasoning of MacDonald and MacDonald is basically that the statutory framework, as it applies to Section 21, incorporates a proper balancing act. That's my take on it. That's how I would summarise it. And I think there's a question mark as to whether that's still true in the context of a public health emergency generally. And specifically, as Tim said, whether that's true in local lockdowns. So it's more of a suggestion, a question that I'm throwing out there. I don't know what all the answers are, but there is scope, I think, for challenging some aspects of McDonald and McDonald in the context of this public health emergency. I think that's it for me. That's my last slide. Thank you. And I'll hand it back to Liz.
There I was talking away. I'm so sorry. I'm now unmuted. It's the modern world, isn't it? Everything starts with please unmute yourself. Sebastian, thank you very much. That was excellent from both of you. We do have some questions, which I'm going to turn to in a moment. Just a couple of points to make. First of all, I always say in respect of eligibility in homelessness that a good lawyer doesn't know eligibility backwards. They know where to look it up. And people sort of breathe a sigh of relief when I say that. And frankly, I think these days the same applies to all sorts of discrete points of law, particularly Section 21 defences. And when I started in practice, it was all about, is the date right? Well, Seb's just told us about what you can do with that. But you now have this long list of compliance by landlords. It's a good thing. It's about regulation. And I always look it up. So the talk today and the slides are an aid memoir to remind you to think about these points and go and look it up. Just don't think you have to remember everything. That's the first thing. The second thing is that the issues that Tim talked about and I touched on in the introduction about what will happen after the 23rd of August are going to be discussed further at the Housing Law Practitioners Association next Wednesday evening for those of you who are members of HILPA. And I know that the co-chair of HILPA, Simon Mullins, who is masquerading on this call as Marina Sergides because they've become interchangeable, would want me to mention that webinar at 6:30 where we're talking about access to justice. And that allows me to publicly say that we're delighted that Simon Mullins was awarded Legal Aid Lawyer of the Year, Social Welfare on Tuesday night. And he would be the first to say that all those shortlisted were brilliant lawyers, and that's absolutely true. And the winner is also a brilliant lawyer, so congratulations to Simon. The third thing to say is I've had a couple of messages where concerned about sound. We will do what we can about the sound before we send the recording out, so please don't worry about that. Right, I've got two questions for Tim and two for Seb, and I'm going to put them to you and take them in that order, and then we'll have one more round of questions, so do put them on the chat. I've not been able to take all the questions. I'm sorry, I do apologise. Jen in particular has said to everyone to share experiences of getting funding to run disrepair counterclaims, and people have joined in. So I'm going to let that happen on the chat. Tim, the two for you. Harriet's question, if it's on the chat if you want to have a look as well. Where accelerated proceedings have been issued during the stay, does the 14-day deadline still apply to the filing of the defence in light of PD 51.7? And I suppose you could address that both in terms of issuing during the stay. I thought that wasn't supposed to happen, but you could check that for us. Or if they're issued on the 24th or whatever the next working day is of August once the stay is lifted. The other one for you, Tim, but I'm tempted to say, because it's a very specific case, that you might get back to Anna on it, is a question from Anna, which is EPC. It's about the EPC. So do you want to discuss that with Anna privately once this is over? So Seb, obviously feel free to come in on PD 51Z if you want to, but two specific, two questions for you. Olivia is asking for you to confirm the point that if there's a disrepair counterclaim, there's no limitation period, whereas of course, if you're issuing a claim for disrepair, then there is. And David has an interesting point, which is about the failure to comply with policies, whether it's Children Act, discrimination, or other aspects in the policies, it can be difficult to show that compliance with the policies by the landlord would have made a difference, given how nebulous the reasons can be for clients to build up arrears or commit antisocial behaviour. We're talking about real world problems here. People have complicated lives and complicated causation and motivation. So he's saying, how do we work out whether it would have made a difference? And does the same apply to Section 11 of the Children Act? Mohammed suggests that it does, but that seems even more difficult to establish. There's also a more general question, which again, I'm very happy for people to discuss in the chat, about what amounts of awards have been made for discrimination and counterclaim. Seb, if you happen to know that, please do come in, but otherwise everybody join in. And then I'll look at the more recent questions and select a couple more before we sign off. Tim, you start.
I'll start with the question about issuing the accelerated proceedings during the stay. There's no prohibition on the stay about issuing proceedings.
Okay.
If you look at the wording of the stay, it says proceedings brought under Part 55. So the claims can be issued, but effectively there should be no processing by the court, because the idea was that this is to protect the court staff and protect the administration of justice. So although it's issued, that it's effectively issued with a stay, unless the landlord can make an application that this is an exceptional case whereby the stay should be lifted. And if you look in Arkin and Marshall, you have to have something really, really, truly unusual and exceptional. And for example, there have been some circumstances where stays have been lifted, but in a bog standard accelerated possession case, no. So effectively, you don't have to file a defence within 14 days. The best suggestion I can come up with is that it's 14 days from the lifting of the stay, because then any processing of the claim starts. So if you've been served with a notice of issue, then I would say that you don't have to file a defence until 14 days after the lifting of the stay, because there is nothing for the court to consider. And if the court did make directions or anything to that effect, that would be unlawful under the stay. I've seen various forms of order issued by several judges at Central London County Court, and I have to say that they would be unlawful under the stay. But I would say that the 14-day deadline would kick in after the lifting of the stay. And if there's any doubt about that, you could always raise that as part of your defence, say that this is the date in which it should be filed. Liz, you're muted again.
I'm muted, of course. Tim, thank you very much. Sebastian?
I think on the EPC thing, I think I have to deal with that by email because it's quite a complicated one. Sorry, I can't deal with it off the top of my head.
No, that's fine. Okay, Sebastian.
Hi. Yeah. So just quickly in relation to Olivia's question, yeah. I mean, there isn't a limitation because it's an equitable set-off, and so you can recover damages for however long you need. But what I would however long you can. But what I would suggest is that you look at a case called and I'm sorry, looking at another screen just to get the citation, British Anzani in brackets Felixstowe Limited against International Marine Management Limited. That's 1980 QB 137. And what that case is about is the connection between the equitable set-off and the original claim that you're facing. It's not a direct answer to your question. The direct answer is yes, you can recover beyond 6 years, and there's no limitation on that. You might find an argument that the issues aren't connected, and that's when you need to look at British Anzani. which is on the point of the connection between the equitable settlement and the claim. In relation to David's question, hello, by the way, hope all is well in Leeds. Yeah, I think you're right. It is difficult, but the kind of things that occur to me are that often our clients are people who need a little bit of extra help in managing their affairs, and which is part and parcel of paying the rent. And many of these policies do speak or address the point of providing a little bit of extra support, and things like having universal credit be paid directly to the landlord is something that would have made a difference if it had been implemented, 6 months before the arrears began to accrue, or actually providing financial advice. It depends. I think it's very fact specific. But many housing associations, as you know, have sufficient resources that they have specialist kinds of advice, and those are the things that I think that should be looked at. One word of caution, though, in relation to Section 11, that it is something that can be rectified. So if a local authority or a housing association, if you can manage to get that to work, hasn't considered Section 11, they still can during the course of proceedings. So that's a word of caution. So yeah, I take your point, David, but I think that it is something that you can make work depending on the facts themselves. And just lastly, on the amounts, yeah, it is not actually that common to get damages in terms of an Equality Act. Fortunately, there is one case. It's called Heart of England Housing Association against Macadam. It's reported, if I recall correctly, it's the December 2018, January 2019 edition of Legal Aid. It was an antisocial behaviour possession claim, and in a nutshell, the housing association failed very badly in understanding the disability of the tenant, and failed very badly to provide any kind of assistance and to coordinate with local mental health workers. The judge, District Judge Bull, who also sits on a mental health tribunal, and that was really helpful because he had a great understanding of these kind of issues. He found two things, actually. He found that the Vento guidelines did apply. Unfortunately, it wasn't contested by the housing association, so there isn't a great deal of reasoning in the case as to that. And he awarded the tenants £3,000 by way of damages. That, as I say, it's reported in legal action. I have the full judgment. I'm happy to share that with anybody if they need that.
Just to add to considerations of what Seb said about what you might call procedural defects and policies, particularly in their application, and whether compliance would have made a difference. I think, again, as I'm very much in the Liz school of what you call the back to basics approach to these things. And often people think that there's an easy answer to them. But if one goes to the back to the basics approach, is if one thinks of a policy as a relevant consideration, and if you look at relevant considerations in the context of Wednesbury reasonableness and how a relevant consideration is considered, it is something that might make a difference. So the starting point is whether it might make a difference. And also there's a particular piece of legislation, I can't remember the exact bit of it, but I think it's one of some of the subdivisions of 31 of the Supreme Court Act 1981. It's when a court considers something, an appellate court or a review court considers something, and when they consider it's appropriate to remit it for a fresh decision or not. And it's useful to look at the approaches the courts take in respect of that provision, and there are particular provisions within judicial review as to when to accept a procedural defect case as making some sort of difference. The threshold generally is very low because it's really who is the primary decision maker. And one of the arguments is whether the court could effectively substitute its own decision in respect of when there's a procedural defect. So it's really people going back to those old, breaking out the law books, blowing the dust off, going back to those very first principles and seeing if you can construct arguments in that way. I think if you are concerned about these things, you do have to make very detailed arguments, and you do have to demonstrate in evidence how that failure, a failure to take into account a relevant consideration of the operation of a policy or part of it, just might make a difference. What the difference in the decision making might, whether it would have been different or not. But it's really to try and persuade the court not to substitute its own judgment on the merits of that relevant matter.
Lovely, thank you very much. We are running out of time. We had 2 more questions. I'm afraid I'm not going to take them. Rosie, you have an amazing question that is both specific and then introduces the whole question of common defences to mandatory grounds for possession on antisocial behaviour, committing offences and so forth. Because we haven't really dealt with that, we've concentrated on rent arrears, although you'd be right to say the title of the seminar is mandatory grounds, not mandatory grounds on rent arrears. I'm going to put that off for another day. Andrew, can you talk us through when a housing association is allowed to grant ASTs? What I would just say very quickly on that is there isn't a prohibition on them doing so, but obviously one would expect them to have the relevant criteria in the policy. And if there isn't if within their policy they don't mention the grant of an AST, which usually happens for a probationary period similar to introductory tenancies, then and your client has been granted an AST, then you'd want to pick it up on the policy. But again, all of the 3 of us, any of the 3 of us, are more than happy to carry on talking on the email about either specific or general questions. There's already been a number of thanks on the chat from many of you. Thank you very much indeed for that. This concludes for the summer our Garden Court Housing Team series of webinars, which we kicked off shortly after lockdown. I think the first one was in the very last week of March, so we did it quickly. We're proud of that. But do watch your email and our website for announcements about what we're going to do in the autumn. And I can say that we will be, even when things get back to normal, we will be considering very seriously whether to continue with webinars, because we're aware of how many more of you can participate. So we're excited by that. So you will receive notification of future seminars, webinars, both by email and from our website. And it just remains to me to thank both Tim and Sebastian. You can't do it in the normal way, but you've all put your thanks on the chat. Thank you for that. A reminder that you will receive the slides and that recordings with sound enhanced will come out. So thank you all very much indeed for your participation. And we do hope we've given you some useful tips. Thank you. Bye-bye.